This is Copyright 1, Part 1, and in this capsule, we're going to cover the overview that's provided at pages 2 to 8 of the textbook. So, the ability to enact laws regarding copyright arises under Section 91 of the Constitution Act, which provides that the federal government has the power to enact laws on things that are not specifically given to provincial governments under the following section. And regardless, we have an enumeration of things that the federal government can enact laws on, and one of these, number 23, is copyrights. So what that means is that as a result, the federal court has jurisdiction to hear cases on copyright. So under the Federal Courts Act, any dispute regarding copyright is going to be heard ultimately by the federal court. It might go through the Copyright Board or any other administrative agency that has kind of original jurisdiction to hear these things. But eventually, it's going to go to the federal court, and that jurisdiction is exclusive. So it means that the provincial superior court, so the constitutional court that we have in Canada, the superior court, which is in every province, cannot hear cases regarding copyright unless, some very, very arcane exceptions where the copyright is going to be basically an unimportant part of the dispute. So, as we said, the federal court has jurisdiction. Parliament has enacted a specific law regarding copyright, which is the Copyright Act. And what that means essentially is that we have a regime that is statutory. So basically, the only applicable rules are going to be the ones that are found in the Copyright Act as interpreted and applied by the courts. And that's basically going to entirely oust any previous rules that existed under the common law. And this is stated more explicitly in the Teberge case, which is cited at page 3 of the textbook, where we are told that copyright in this country is a creature of statute, and the rights and remedies it provides are exhaustive. And so the only relevant common law rules, so court-made rules, are going to be the ones that have arisen as courts have interpreted the Copyright Act and the rules specifically provided in the Copyright Act. And in the same case, we're introduced to a very important distinction, which is going to exist throughout intellectual property law, where we are told that copyright is concerned with the protection of economic rights, and that is in opposition to moral rights. And that's very significant because it limits the purview of things that the copyright holder, the person who holds the copyright, can prevent other people to do. So to give an example of that, that is not necessarily rooted in literary works or copyright, but a more kind of general example of this is, let's say I make a very nice statue. And so I'm going to have, say, a right that someone cannot copy my statue, cannot make a statue that is either the exact same or substantially the same, and I'm going to be able to prevent the person from doing that. Now, something else that the person could do is not copy my statue, but then they could, say, put toilet paper over it. And that would be very embarrassing because I'm an artist and I've made a nice statue, and I don't think that it conveys the same meaning when there's toilet paper on it. But that person hasn't copied my statue. They haven't taken my statue. They've only kind of changed its meaning without altering its nature or its physical nature, to put it that way. And so that's going to be the distinction between a moral or an economic right. A moral right is going to be a right that is not economic. So a right to protect my work or the nature of my work or what people can do with my work, but that is not really about someone else using my stuff to make money. And so we are told that the copyright protections in Canada are concerned only with economic rights. So I write a book, right? And then I can prevent someone from taking my book and then making money with it. But the range of things that I can prevent someone else from doing is limited by the purpose of copyright protection, which is to protect my economic rights, to use this stuff that I've created essentially to make money. And we're told as well later on that copyright protection does not necessarily arise from registration. That's going to be an important distinction as well that's going to go beyond the law of copyright that we're going to find in some other areas of intellectual property law. And so registration as either a condition of existence of a right in law, or simply is evidence of the existence of a right in law. And so this is an important distinction, because if registration, right, is necessary to the existence of my rights, that means that I can only prevent other people from doing things with my stuff, and that's, say, my book for copyright protection, until I've registered my rights. So until I filed paperwork with my lawyer and sent it to the government, and the government put it in a registry that is public and through which people can know that this stuff is mine, that they can't do anything with it. That would be existence. The contrary, we can have a system where registration is not a prerequisite to the existence of a right. It is simply evidence of the right. And so in the case of my book, and as copyright law provides, registration is not necessary. So I can prevent someone from copying my book even though I haven't registered my right, because my right exists independently of registration. And so registration is not mandatory. So why would we want to register a right? Because it is evidence of my right. So even though we know in law, right, that I have a right to prevent people from copying my stuff, it might be easier when I go to court and try to get money from them from having done that. It might be easier to prove that they've infringed upon my rights if my rights are known to all because they're in a public registry. And so we have a register of copyrights in Canada that is created under the Copyright Act, but under that act, registration is not necessary. And then we have, again, the Theberge case, which discusses a key concept, the first key concept of copyright law that we're going to look at, and that is, and I quote, that copyright is not to protect the ideas or opinions expressed by the creator, but rather the various means and forms by which those ideas are communicated. And so what we protect is the product, to put it that way. And that's an important distinction, again, that we're going to find in other areas of intellectual property law beyond copyright. So if I write a book, this may sound like kind of an arcane distinction, but it's one that is important as we're going to see more specifically in other areas of law. What the law protects is not what is in the book, it is the book itself. And so it's not the ideas that I've expressed in the book that are protected directly right, as they might be in some other areas of law, but it is the book itself. And so the fact that I've thought of a story, or I've told people a story, that doesn't make it protected by copyright law. In fact, it prevents it from being protected by copyright law, because the idea is not fixated or otherwise expressed on a medium. And so in that case, what the law protects is the book itself. And so I can prevent someone from copying my book as I wrote it, but I can't prevent them from using my ideas in a different way. And that's also going to be a concept that's going to be important in terms of determining when the right to protection is triggered. Because that also means that the very same idea, until it's expressed on that medium, is not protected by the law. And so if I tell someone of a story that I want to write, well, in that case, they can steal my story, they can steal my ideas until and unless I've written them down on a medium that's otherwise protected by copyright law. Again, in the textbook at page 6, we are introduced to yet another kind of related distinction about the purpose, nature, and justification of copyright protection, and that is the intrinsic tension between the public interest and, we'll call it, to make things simple, the person's interest, right? That's going to be distinction. It's going to be important again beyond copyright law. So we're only at page 8 of the book, and we've already introduced some very important distinctions that underpin the law of intellectual property more broadly. The distinction between economic and moral rights. The distinction between registration as a necessity to the existence of a right, as opposed to registration as simply evidence of the existence of a right. And here, the justification for the law of intellectual property, and that is to favor people doing things that the government thinks are important aspects of the human experience. And so we want people to write books, and we want people to write poems, and they're not going to do it if someone can just steal their stuff and put their name on it, or steal their stuff and make millions of dollars with it. And so the way we protect that is by having a right that is of a kind of different nature than other rights, different from property rights, so my right to my house, that's a right, or my right to the performance of a contract, that's also a right, but it's not a right between me and a thing, opposable to other people. It's a right between me and another person. But here we have a right between me and a thing, but a thing that doesn't exist, that doesn't have material existence, intellectual property. And so my right to an intangible thing and the way in which it is exploited for economic gain, and again, it is a right that is opposable to all. And what we get with that, when we unite these kind of two aspects of rights, is what is essentially a monopoly. And so I have the exclusive right to make money with my stuff, to the opposition of everyone else. So I'm the only person that can take my book, sell it, and make money with it, and I can prevent everyone, not just one party I've contracted with, but everyone from using my book and making money with it. I have a commercial monopoly. And to add to that, a commercial monopoly that only exists because the government created a specific law, in this case the Copyright Act, that says that I will have this commercial monopoly. And so that's what makes copyright protection unique from other rights. It's also what makes intellectual property law more generally different from other rights. And to get back to my earlier point, it's significant because the government grants me a monopoly that I would not otherwise have. And so the monopoly does not arise from my right to contract with someone else, right, and have them consent to it. It arises from the government saying, you'll get a monopoly. And so this is not something that arises out of nature. It's something that is specifically created by the government that can be taken away by the government if the regime changes. And so, to move beyond that, why do we have this monopoly? Well, it's because we want people to do things. As I said, I'm not going to write a book if I know that someone else can just take it and make money with it, right? And so the government is going to say, well, I think it's important for you to write a book. I think it's two justifications here. It's in the public interest for people to be incentivized to write books, because we think it's important in society, right? That some people, when they're talented at it, take their time and instead of, going to a factory and making things, that they write books, and then books that everyone else can enjoy. And that's important to the advancement of our society. And second, the government thinks it's also in the public interest that it's fair to me that I be the only person that can make money with the book. And so this monopoly, we think, is justified because it wouldn't be fair if someone could take my thing I've made when they haven't contributed to it and make money with it. So that's kind of the two aspects of the public interest that arises here. But, right, the other thing that arises out of that is, well, when I've written a book, who is going to be able to use it? And from the monopoly I've just described, right, another thing that kind of comes with that is that, well, I'm not going to, I could technically prevent everyone else from doing anything with it. And so I write a book, right? And as we said, I have what is essentially a commercial monopoly. I'm the only person that can take the book, sell it, and make money with it. Well, what comes with that is, well, I could prevent everyone from using my book and keep it to myself. And that also arises from the very nature of the commercial monopoly I've just described. And so there's also a contrasting and opposing public interest in making sure that ideas are disseminated. So there's an interest in making sure that people can access my book. And once it's protected by copyright law, even though I may not do it, I am technically able to prevent everyone from using it. And so copyright or intellectual property protection is not a universally good thing because it incentivizes me to write books because I can make money with them. It's also to have broad protection of intellectual property. It's also potentially a limitation to the ways in which people can access, use my stuff, right? In my example, it's a limitation to, I could say, I don't want to sell my book, and so no one's going to be able to buy it and enjoy it. Similarly, same idea, but somewhat expressed somewhat differently. Once I've claimed protection, of intellectual property. Most of the time, it's going to mean that someone else is essentially unable to do the same thing. And so we'll talk about this in far greater detail, but there's something that is in the public domain, right? Or is just out there for the taking for someone to do something with it. Then once I take it and do something with it, and that becomes the subject of intellectual property protection, then that limits the ability of other people to do that, because that thing is no longer out there for the taking, it's mine. And so that also limits what people can do. And so from this overview, we can see this last distinction between the public interest in the dissemination and use of ideas, right? The ability of people to access my stuff, read my stuff, use my stuff, to come up with their own stuff, as opposed to my interest in profiting from my ideas, which incentivizes me to have these ideas in the first place. And even though these two things can be described as kind of in the public interest in a broad sense, right? There are things that we as a society want to favor, to incentivize. In actuality, they act, they're in opposition here. And to have broad protection of intellectual property has consequences on the other thing. And the opposite is also true. So the last thing that we have in this overview section are two kind of brief but important concepts. The first one is that we can have the coexistence of various intellectual property regimes in the same thing. And so you're given the example of the Michelin drawing, and we're told that one of them, if my memory serves me well, is the subject of both intellectual and trademark law. And so these things, these regimes, right, so we're going to see trademark law much later on, but they're not mutually exclusive. And that's going to be obviously especially true when the regime is one where registration is not required. And so oftentimes we might have a thing, in that case a drawing, that is protected by, say, copyright law by its own nature, without registration, without formality, by meeting the legal requirements. The thing is automatically protected without me having to do anything to ensure that. And we might also have very same thing that can be subject to trademark protection by, say, me registering it. And so these things are not mutually exclusive. The same thing can be protected by both copyright and trademark law. And that often, but not always, that's just an example, often arises out of one regime requiring formalities to registration and the other regime not requiring these same formalities in registration. The last example we're provided with, right, is the copyright symbol, which we've all seen on stuff, right? And if you ever become a lawyer, you'll learn about it, because every time you're going to try to put a C in your list of things, it's going to turn into a copyright symbol. So the copyright symbol also helps us understand the distinction between registration as a requirement to the existence of a right, or as evidence of the existence of a right. So a copyright symbol cannot be necessary, right? Because as we said, copyright exists kind of by itself. When we meet the statutory requirements of the Copyright Act, we have a copyright without registering it. Well, from that, we necessarily know that this symbol cannot be required because there's no legal formality. And conversely, it cannot be required as evidence of registration either. And so the obvious reason you would put that there, right, is the same reason you'd register your copyright. First, right, to make it easier for you to go to court and prove that you do have a copyright. Second, to make sure that everyone else knows that you have a copyright. So this thing, right, you tack it on to your company name or to your drawing to say for everyone to know when they see it, when they read it, that it is protected, right? Like you put a seal on it and then people know that they can't copy it. And so that acts again as evidence of the right, especially as evidence of the right in enforcing it against other people. But as we said, is it is not necessary, right? It also means that even if I've registered my copyright, I cannot be and am not required to put the symbol, because registration, again, is optional and is not necessary. So even if I've registered it, I don't have to put the C on it, because registration and the symbol are independently, but in the same way, neither necessary to the existence to the existence of a right, nor necessary once a right is registered to proving that it actually exists.